Welcome back, dear learners. Today we will understand the appointment and legal position of directors. Let us begin with the appointment of directors. Now have a look at the screen and see how the appointment of the directors is done. So the appointment of directors can happen through various ways. The first directors are appointed in the articles, or they may be the ones who subscribe to the memorandum. Next, the directors can be appointed in general meeting. Directors can also be appointed by board of directors, by small shareholders and by tribunal. Now we will understand all these appointments in detail one by one. Let's start with appointment of first directors. You all have studied types of directors and you know that the first directors of a company is appointed in the articles of association of a company. If the articles of association of a company do not provide for the appointment of the first director, the individuals who are subscribers to the memorandum shall be considered the first directors of the company until the directors are properly appointed in the meeting. In the case of a one-person company, the individual member shall be deemed the first director until the member appoints a director or directors in accordance with the provision of this section. Now let us come to the second type of appointment, that is appointment of directors by board. The board can appoint additional directors if articles of association of the company are giving them the right to do so. Board can also appoint directors to fill a casual vacancy. A casual vacancy arises when the position of a director gets vacant before the expiry of the director's tenure due to resignation, disqualification or death. Board can also appoint an alternate director if articles are permitting to do so. Next is the director appointed by the tribunal. If the tribunal receives an application under section 241 under which members or shareholders of a company file a petition that the affairs of the company are not being dealt with fairly, then the tribunal may order the appointment of certain individuals as directors of the company. It can also ask these directors to report back to the tribunal on matters the tribunal directs. The directors appointed in this manner may or may not be members of the company. When calculating 2/3 or any other proportion of the total number of directors, those appointed by the tribunal will not be included in the count. These tribunal appointed directors are not subject to retirement by rotation. However, they can be removed by the tribunal at any time, and the tribunal may appoint new directors in their place. If the tribunal has appointed the directors, it may also issue a necessary or appropriate direction to the company regarding the affairs of these directors. Appointment of directors through proportional representation system. Under section 163, the articles of a company may allow for the appointment of not less than 2/3 of the company's directors based on the principle of proportional representation. This can be done through methods like the single transferable vote, cumulative voting or other systems. Such appointments can be made every 3 years. Here you should remember that in case of government companies, section 163 shall not apply to a government company in which the entire paid up share capital is held by the central government or by any state government or governments, and a subsidiary of a government company in which the entire paid up share capital is held by a government company. Next is the appointment of a nominee director. A nominee director is a director appointed by a financial institution, government or any other person to represent their interests either based on a law, an agreement or other arrangements. A nominee director is not considered an independent director. Companies that receive financial support from other banks, financial institutions, major shareholders or debenture holders often give these lenders the right to appoint and remove their nominee director from the company's board. This power is usually included in the financial arrangement. These lenders, such as banks or institution, may also require the borrowing company to change its articles of association to allow them to appoint and remove their nominee directors whenever they choose. These nominee directors do not have to retire by rotation and serve at the discretion of the institutions that nominated them. The company cannot remove them. The process for appointing a nominee director is the same as appointing an additional director by the board or electing a director other than a retiring one at a general meeting. Depending on the terms of the agreement with the appointing institution, the company can choose either of these methods for the appointment. A company can also appoint one director who is elected by small shareholders. Small shareholders means a shareholder who is holding share of nominal value which is not more than 20,000 rupees. A small shareholder director can be appointed by a company who has at least 1,000 small shareholders or at least 1/10 of their total number of shareholders are small shareholders. A small shareholder director is appointed in order to give them representation in the board. As per section 152 of the Companies Act, every director must be appointed by the company in a general meeting. According to section 152, subsection 6, the articles of a company should make a rule that all the directors of the company will be retiring by rotation. If the articles are not making any provision for the retirement by rotation for all directors, then not less than 2/3 of the total number of directors of a public company shall be liable to be retired by rotation and be appointed by company in general meeting. Also, there are certain rules related to every type of appointment, which includes that every director who is appointed should have a director identification number or DIN. He or she should not be disqualified from being appointed as a director. And finally, all the details of the appointment should be filed with the registrar of the companies. Let us now move to the next part, which is the legal position of a director. The legal role of a director in a company is complex, as they serve as agent of a company and take action for the company. The directors are also the trustees of a company, which means that they can manage the assets of the company in the best possible way. Next, it can be said that the directors are the managing partners of a company because they act as the representatives of the shareholders and carry out the will of the shareholders in accordance with the objectives of the company and officers. Directors represent the shareholders holding significant authority and making important decisions. They operate under the company's governing documents, which grant them supreme authority. Additionally, it can be concluded that directors have a fiduciary position in the company, meaning they must act with care, good faith and diligence in the best interest of the company. This multifaceted role highlights the crucial responsibility directors have in guiding and protecting the company's operations. With this, we come to the end of this video featuring the director's appointment and legal position. Thank you for listening and happy learning.